resolution of that matter, because Malawi wants to prospect for gas and oil and the like. But the SADC tribunal has been suspended by the same political leaders in order to do this review. They even wanted to abolish it. But now a dispute has arisen between member states of SADC. It shows now that these political leaders now need the SADC tribunal more than the citizens that were going to it. They now need it much, much more. And now, the focus for civil society is to continue to lobby that the protocols that they pass relating, say, for example, regarding the dispute between Malawi and Tanzania relates to water resources and how they should be shared, affects the economic development of nations, affect us as citizens. So we should be able to lobby these supranational bodies, lobby the regional organizations to ensure that they strengthen them so that they can be to our benefit. Maria will, in a later discussion, speak to you a lot about the work that AfricanLII is doing. But it will be remiss of me to leave without talking about the challenges. One challenge that you have with distribution via the internet is that you open access to everything. And that open access itself is not entirely a safe mode. There are issues of privacy relating to the participants. Take, for example, the International Criminal Court, the Special Tribunal for Rwanda, what you see even coming out of the ICCs, victims of sexual offenses of the most barbaric kind. You can put a name to a face of the victim. You can put a name to the name of a victim. You can put a name to the village in which it happened. This creates a new challenge because, as you know, with sexual offenses, we want to protect the privacy of the victim. It's a challenge. When we put our information out there in the public domain, we ought to be able to ensure that we do not unfairly publish material that prejudices the participants in the legal process. The reuse of the information. It's a challenge that is greater at the national level, where a person's information, that is personal information, that finds itself in the domain of the internet can be reused. Certain disputes require that even banking details be disclosed in the hearings. Not necessarily that there should be judgments, but judges love to put as much information as they are given. So I even find cell phone numbers in some of the judgments that we see, which then exposes that person's privacy to manipulation by the numerous fraudsters whom we know to inhabit the cyberspace. So we need to look at the security of the information, identity theft, and also to ensure that when we collect and publish this information, it is accurate. Because the moment it goes into the cyber domain, it's like hoaxes. I mean, how many do you receive in your mailbox that tell you that the world is going to end in this date or something has happened, and you look in newspapers in that country and not a single report relating to that? That is part of the danger of cyberspace. And whatever we develop, we must ensure that our policies are alive to these dangers and we are able to mitigate them. We may look at individual legislative limitations on the content of the information. I prefer policies that are like that, so that the judges themselves, when they prepare their own decisions, they are alive to these issues. We also would like lawyers who are active and proactive to say outrightly, the identity of this person who is a witness must be protected by the court. And the court makes that order so that we already at the processing level have limited the risk of invasion of privacy. Other challenges that we face are that there is lots of information in boxes and archives that is not digitized. And it costs a lot of money for us to go to this important material, to digitize it and make it easily accessible. We also have challenges with internet connectivity. There has been a dramatic improvement, dramatic growth, but we still have general challenges with access. The courts that we have are poorly funded. As we know, the judiciary is the weakest arm of government, with neither sword nor purse. The legislatures and the executives, the arms, normally get what they want because they are involved in political horse trading. The judiciary is weak, it's poorly funded. So the poor court infrastructure results in poor provision of service, results in poor access to their own decisions. It's very hard to get some of the older decisions. It's only now that you find in some of the countries there is a semblance of collection of legal material. The example given by the Honorable Chief Justice regarding the old law reports in the old statute book in Seychelles is not unique to Seychelles. It's the same situation outside South Africa in most jurisdictions that you find, particularly in sub-Saharan Africa, that you rarely find updated statutes. Our law schools are challenged in terms of teaching IT skills. We should, if we are going to have greater impact in terms of sharing information through IT, we should improve the training quality of the young practitioner, make them more adept at using the internet, make them more adept at using IT tools. As I have indicated, it impacts on the quality of service and the costs. So if you are going to get a lawyer who can't search on, say, Kenya law to find the latest Kenya law decisions, you are going to pay more for that lawyer. You might as well walk in the law firm and say, I'd like you to help me, but can you use the internet? Because it has a direct impact on what you are going to be charged because of the traditional billable hour. So we need to up those skills. For the future, we need to build reliable and sustainable internet-based reporting across the continent. We need to ensure that there's greater access to legal information which impacts on access to justice. And for the future, we hope that by so doing, we'll have greater consistency for African courts and greater sharing of experience. I thank you.